All rise. The Honorable Court of Appeals for the 7th District of Texas is now in session.
Please be seated. I don't know, I didn't move it, so I don't know. Good morning, we welcome you to the January 8th, 2025 settings of 7th Court of Appeals in Amarillo, Texas. We appreciate you traveling. Some of you live in Amarillo, but the others who don't live in Amarillo, we appreciate you traveling some distance to get here. Hope you are enjoying the weather. This part of Texas, it could get a little tougher, but it's going to turn out to be a nice day here. We'll reach the 40s, so streets should clear and such. We'll go on and call the docket, and you should have already been told the amount of time you have, each side has. Of course, the appellants have an extra 5 minutes for rebuttal. You don't have to, you know that, you don't have to worry about requesting it. So I'll dispense with that. I would do ask that, and as some of you know, we're prone to ask questions. Please answer the questions as best you can, as directly as you can. And hopefully things will go smoothly and talk to us. Don't lecture. Only my mom can lecture to me and my wife. But with that, we'll go on and call the first case for this morning, 07-23-00421-CV, Southwestern Public Service Company versus Ridge Renewables, LLC. For the appellants.
For the appellants, John Smithy, and it's for Southwestern Public Service Company, and also Dusty Stockton.
Okay. Ms. Smithy, you're going to be the only one tendering argument, or? Very good. And for the appellees?
For Ridge Renewables, the appellees and cross appellants, Corey Waymeyer of Centoya Waymeyer PC. I'm joined by my colleague Renee Hunt. And we're ready.
Welcome, welcome. Will you be providing the sole argument?
I will.
And you'll be reading the note sheet passes to you, right?
I will, and I'll be the one scolded on the right back.
Okay. Well, thank you very much. And with that said, Mr. Smithy.
May it please the court, counsel, as the court's aware, there's been a lot of briefing.
Very quickly, there is water down there if you want some water during your argument, so do not hesitate. Thank you.
There's been a lot of briefing in this case. It's been, I think, adequately briefed. There are a lot of issues. I think I would say more issues than you normally see in a case. I've tried to narrow those down for the court today. It's not an exclusive list of issues. We had filed kind of a list just to kind of give me a guideline what to argue. And let me go through some of those. And if the court wants to focus on anything in particular, that's great.
And I'm sure you did, but you provided this opposing counsel.
Yes, I served it, on the portal and everything.
Thank you.
So the first issue that I wanted to address this morning is, what did the judgment actually adjudicate? It's an interesting issue in this case because a large part of the plaintiff's action was for a declaratory relief. And they sought declaratory judgment on, I think, 5 elements. Well, it was granted by summary judgment, apparently. But the summary judgment made no decretal recitals. And so it just said the motion's granted. So
Shades of Sunday Canyon?
Yeah, the Sunday Rohrman versus Sunday Canyon. So when we discovered that case, we asked the court for supplemental briefing, which the court was gracious enough to give. And basically, we don't have a real strong position on this. We in fact, we just think the judgment's in error, the judgment for over $1 million. And we would really err on the side of clarity, and the judgment if can be construed with clarity, but it does raise some issues. So, so you've got the lack of decretal language in either the summary judgment order or the final judgment. And then you have the.
What would be the effect of that under Sandy Canyon?
Well, under Sunday Canyon, I think, you know, this court cited some other cases and said it adjudicates nothing. Now, they came back and pointed out that several months after that, this court decided the Ball versus Barley case. And so I don't think those cases are necessarily in conflict, but they kind of give two sides to the same issue. And so in the Ball versus Barley case, there was a notation on the court's charge regarding the summary judgment. So this case tracks both the Brorman case and the Ball case almost identically, because there
Wasn't one of the differences though between our case right now and Sunday Canyon was that Sunday Canyon was really just a summary judgment and the court just said the summary judgment's granted?
Yeah.
Is that right?
I think so.
One difference here that we've got is that we've got a jury trial that followed the grant of a summary judgment. And it seems like some of those issues were incorporated into the jury charge by having the jury say, well, you know, we don't have to handle the first question about who owns the land.
And there was a recitation in the jury charge, and the court can see it, that said the court has found by summary judgments that bad faith trespass, that SBA has committed bad faith trespass. So I don't know what the effect of that is. And I mean, that's a problem for the court, you know, but and like I said, we're not going to argue that really hard. I mean, we just think at some point to review the judgment, the court's going to have to construe the judgment.
Right. And one other part of that is, I guess, in this case, the final judgment actually incorporates the jury charge. That would have that language. Right?
It does. The language incorporates the jury charge. And I think that's a good point.
You indicated that summary judgment, though, under the motion for summary judgment involved a request for a declaratory judgment?
Yes.
Declaration. So would that exceed the topic of trespass? There are other things to be adjudicated under the.
There were, yes, Your Honor, there were other things in the motion for summary judgment. It was broader than just, that was one ground of the summary judgment. And I think that when you're dealing with a declaratory judgment as opposed to just an ordinary judgment, the requirement for specificity is a little stronger, because if the court's going to declare something, it needs to be very specific and precise about what it's declaring, because that's basically setting the rights of the party. So you don't have that here. Also, in the legal description, you don't have in the judgment, you don't have a legal description.
Mm-hmm.
So part of their action was a trespass to try title action. And, you know, that's an interesting situation, because when a plaintiff gets an adverse judgment in a trespass to trial case, and the court here had a Mother Hubbard clause in the judgment, which denied all relief not granted, didn't grant the title or possession specifically, but denied any relief not granted. In a trespass to trial title case, you have a presumption that superior title was in the defendant. Now, it doesn't mean the defendant owned the property, but it just means that the defendant's title was superior to the plaintiff's title in that case. So I brought you an interesting issue. Good luck with that one. And so, you know, and I like to say, I think what we're after is just some clarity here, you know, so the second thing, which I think is probably more consequential, is the issue of whether Ridge's motion for partial summary judgment established as a matter of law that the 2000 wind lease was void for a lack of an adequate legal description. It's a very interesting issue. So this court, I know, is very much aware of the test. The test is, can a person generally familiar with that locality take the information that's provided in the legal description and go out and identify the property in question with reasonable certainty?
Is that a question of law or a question of fact?
It's I think, I mean, my view is it's a mixed question because, I think, here's the thing. I think because this was a summary judgment motion on an issue that the plaintiff had the burden anyway, and certainly in filing a motion for summary judgment, they had the burden. I think their burden was to show that why the property could not be located from the description that was given. And, courts have been very lenient. They make every effort to try to figure out where this property is. That's what courts do. They want the conveyance to succeed instead of fail. And so you have a description here that says it's owned by Glendale King 100%. And then it says all that real property of Hale County, Texas, 256 acres. And it's out of the south part of the east half of section 58. Though that's the pertinent part. And so we all know most sections have right at 640 acres. The east half would have roughly 320 acres. And so the lease was for 256 acres out of that. So I think if you're moving for summary judgment on that, as Ridge did, I think you've got to show, first of all, that Glendale King owned other property in that half section so that it would make identification of what he was leasing impossible to identify. The other issue that we have here is the description refers to an abstract 1695. That is not in the summary judgment record. It's not in the trial court record. And so you would have
That
to.
exhibit A or something like that?
Pardon?
Correct me if I'm mistaken, but I thought I read something about an exhibit A.
Yeah.
Is that the abstract or?
No, the lease just says more fully described in exhibit A. And so exhibit A describes the property. And so
There's an exhibit A to an exhibit C.
yeah,
I think is what the chief is pointing out.
Okay.
Right? Your summary judgment evidence that came in, the 2010 lease was
Exhibit C.
included in summary judgment exhibit C.
Yeah.
But that exhibit has
Exhibit
attached
A.
to it what it calls exhibit A, which
Yeah.
is the
legal description.
legal description of the property.
So, our view is that Ridge had that burden. First of all, to show what was in the abstract, because when you reference another document, that's part of the legal description. And the trial court would have to know what was in abstract 1695 to know whether the description was adequate or not. And the other thing is you have to show that circumstances that would prevent somebody who's familiar with the property from going out and identifying it. Now,
Coons.
Pardon?
Who's Coons?
Kuhn was a right-of-way agent for SPS, and he was their evidence that they put forward on summary judgment was the testimony of Stephen Kuhn. And Kuhn testified that, the question was asked, can you identify the property from just the description in Exhibit A? And he said, I couldn't. Now, that's the wrong question to ask for two reasons. One, the test is not whether Mr. Kuhn could identify it. The question is whether any person reasonably familiar with the area or the locality could identify it. The other reason that it's not the right question is because you're not limited to just the information that's in Exhibit A, but you also look at any instruments that are referenced in the legal description, which once again is that abstract. And then this court years ago did the Lynn versus Houston Community College case, where it says the court can and really must consider parole evidence. And the courts look specifically at what I just mentioned, and that is that if you look at the record and you see that Glendale King just owned, this is only land he owned in that half section, that's a sufficient legal description because the court or anybody else can go out and determine what was leased. Now this court has seen, and I know because I've had some really difficult leases and some leases that were far from perfect. And you know that legal descriptions, very few legal descriptions, particularly in oil and gas leases, ever are perfect by any means. But the thing about it is we have the summary judgment burden that was squarely on Ridge. and they failed to prove that the property could not be identified from the description that was given.
I want to make sure I understood what you were saying just a minute ago, though, because we're talking about use of parole evidence. One of the things you said in your brief, you cited the Long Trust against Griffin case. It says extrinsic evidence may be used only for the purpose of identifying the property with reasonable certainty from the data contained in the contract, not for the purpose of supplying the location or description of the property. If we're talking about providing additional information on whether Mr. King owned the property or anything like that, doesn't that seem like that would be extrinsic evidence for purposes of supplying the location or description of the property?
Well, I would point the court to the Lynn case out of this court. Because this is almost the identical situation that the Lynn case cited. And that they said, if you can show that that landowner only owned one parcel that matches the legal description, then that's an adequate description.
Now, obviously, our friends in Austin would think that their precedent trumps ours, though.
Yeah. And so, you know, it may, there's not a real bright line as to what constitutes what parole evidence can be used. But I would say, again, courts have gone out of their way to try to identify property.
Well, and I guess that's why I was trying to get back to the question I asked earlier, whether it was a question of law or fact. Do you have three people in robes trying to make the decision? Well, I could determine the property based on the reading. Do you put witnesses on the stand and have one after another saying, well, I could look at it and determine it. I couldn't determine the property. And what's the test we look at there? I guess that's part of what we've been trying to determine what's going on.
Well, and there are some cases where evidence was admitted, either affidavit evidence or testimony of someone who was a surveyor or an individual who testified, yes, I can identify this property from the description. And one of those cases is, and in this case, we had the affidavit of a surveyor who came in and said, I can identify the property from the legal description that's given. Now, they objected because they said it was a conclusion, but it's a statement of fact. It's a factual statement. I can identify from the description. It's sufficient. And it's a fact that could be readily controverted if untrue. In other words, if you couldn't identify the property from that description, that could be easily rebutted. And it wasn't in this case. And so the trial court just had insufficient information to determine whether the legal description was inadequate so as to make the lease void. I'll move on to the First Amendment. So this lease was a 7-year lease, and it was getting ready to expire. And so they went back, whoever owned that, the entity that owned it went back to Mr. King and had him execute the First Amendment. Now, in the meantime, Mr. King had sold the property, but had reserved certain rights in the wind. And so the question is, and this is a pure matter of law, and that is, did that First Amendment operate to extend the lease? Well, it says it'll run another 7 years, which would have put it into 2020, the development term. So they had 7 years to develop the lease, SPS did. And then once the development term expired, if development of wind had occurred, then it would go into the secondary term, which was for a long time. So the First Amendment, that's a legal question that the court just has to read the lease and determine what it says. We I think adequately briefed that, but our position is that it was extended by the First Amendment. Now, so our position is that the legal description is sufficient, and the First Amendment extended the lease until 2022, and that we commenced construction of the wind turbines prior to that. And so as a result, the lease is still valid today.
That just pretty much dependent upon what was meant by effective date.
Effective date. And as we briefed the court, effective date is defined in there. There's a definition of effective date, and it says, unless it is specifically defined in this amendment, you go back to the old contract, but it is specifically defined in the amendment. So our position is that when you read it, you can reach no other conclusion that the effective date is as defined in the amendment.
Did the amendment, again, it's been a while since I've read the briefs, but did the amendment specify a period of time that was constituting the extension? Did it say 1 year, 2 years?
7 years.
It says 7 years.
7 years, that would have put it through 2022. And the development did commence within that time.
And opposing parties are arguing effective date really related to the original.
They're saying that that you go back to the original lease and effective date is the same effective date in that lease, but that
What would be the 7 years?
Well, the lease would have expired in 2017.
2017.
Under.
Right.
and the wind development commenced, I think, in 2018.
Understand, under the
Yeah.
first lease, how long was the period?
7 years.
7 years.
Yeah.
Under the second lease, it was 7
It said
years.
7 years from the effective.
So if you were to take effective date and apply it, say it referenced the original effective date back in 2010, there would be no extension.
That's right. If
So
it referenced
would
that,
that be what someone would argue to be kind of an absurd result?
yeah, you could argue that, but the First Amendment specifically defines
Understand
that.
that.
Yeah.
But the-
And that's
It
the,
may be arguable that there's an ambiguity as what is meant by effective date. I understand that there's a definition of it in the First Amendment. But if there's an ambiguity, wouldn't you have to look at the entire document as a whole to determine what was meant? And one of those provisions in the entire document as a whole in the amendment is we're extending it for 7 years.
so you harmonize the agreement, and if you can't come to a resolution, you declare it ambiguous, and it's a fact issue. So on a summary judgment, you can't get a summary judgment when you have a fact issue. So but it's, I think, purely a question of law, really. Another big issue in this case is what specifically rights does Ridge have in this property? It's very interesting. Their so-called wind deed that they received from King was very broad. It was much broader than King's reservation. King basically reserved two things. Or attempted to reserve. We don't even know if you can reserve wind rights or anything to do with wind.
Why should you be able to do that? You can reserve water rights, you can reserve rights and sunlight coming down onto your land.
We're not really arguing that you can't. I mean, we don't know. There's just no case authority that I'm aware of that says, yes, you can, or no, you can't.
Well, maybe. I mean, there are cases involving nuisance, for example, where you contract with a neighbor and say, I'm gonna pay you X amount, don't pollute on my land. And I think there's an argument there that if we're talking about particles traveling over in the sky.
So in that case, you have a distinction, is it a property right or a contract right? And so I think I think there's clearly a contract right here, but whether it translates into a property right, I don't know the answer to that. So what he reserved was a lifetime interest in royalties. Now, at the time, he had this lease, he thought, with SPS. And so he wanted to keep getting the royalties. And he also purported to reserve during his lifetime, the right to lease the property for wind. And then at that point, when that was done, when he died, everything reverted back to the Smalleys, who were the new owners of the property. So under the Cockrell case, their Ridge's ownership is limited to what King purportedly reserved in the deed. I'm out of time. Any other questions? Thank you.
You do have 5 minutes, but.
Thank you, and may it please the court, an honor to be able to be here and present on a topic such as these wind rights, which is a very, in some respects, novel topic and exciting topic for Texas in this area of the world. Justice Doss, to answer your question squarely, whether a contract fails for a property description under the statute of frauds is a pure legal question. It's subject to de novo review. That's the Rossman versus Bishop Colorado Retail Plaza case. 455 Southwest 3rd, 797.
Well, that's my understanding of the law. I'm curious how that's actually applied in actual practice. I know during deposition testimony with Mr. Kuhn, for example, you ask questions to say, well, at least SPS couldn't determine it. If it's a question where we don't look at any evidence at all, then I'm just curious about where we apply that.
in Justice Doss here, you would use the summary judgment procedure. And so there's two ways you get to the correct answer here, which is what the trial court did. The first one here, we can just look at this description, and counsel alluded to that. If you're talking about trying to find 256 acres somewhere in the east half of section 58, we can all look at that description and say, you don't know where the 256 is because this is a regular 640 section. And so you're guessing out of 320, where would the 256 be? We had a summary judgment burden to bring the court some evidence that that failed the statute of frauds. We did that with the corporate representative testimony of Mr. Kuhn of SPS. Mr. Kuhn was not only testifying in an individual capacity, he was testifying in a binding fashion for the company. He was asked, with this description, can you locate the 256? He says no. At that point,
Opposing counsel said that that's the wrong question, though, as opposed to can you find it, should be, well, I guess a reasonable person find it.
Your Honor, I would disagree in the way that counsel's characterized both the test and the way he's characterized the deposition testimony. If you look at the deposition testimony, which is part of the summary judgment record, which is part of the clerk's record, and the question was fairly presented of using this description, you have no way to find the property. That accords with the prior case law on the issue, Lynn case, other cases. But, and again, you can just look at the description on the flat exhibit A, and you can tell there's no way to find this thing. But under the summary judgment procedure, Justice Doss, you would then revert to the burden within shift. So we've presented some evidence that meets this burden of showing it fails the statute of frauds with the corporate representative testimony. They needed to come back with something, and they spent a lot of ink in their briefing on the concept that, well, if you could prove that Mr. King only owned in this one particular 256 acres on some of these lines of cases, that's good enough.
Well, I may disagree with you though on the summary judgment standard. I don't know that it's necessary, that it's sufficient that you produce some evidence. I think you have to produce conclusive evidence.
In the test for conclusive evidence is whether it's evidence that exceeds a scintilla, that is uncontroverted. And on this record, the evidence from Mr. Kuhn exceeds, as the corporate representative, exceeds a scintilla, the 166A standard. And it was conclusive for the reason that SPS, in responding to the summary judgment, did not offer any affidavits that said, this is all Mr. King owns in the section. And in fact, in some of the cases that are cited on this issue, there was trial testimony from folks that says, we did an examination, this was all they owned.
What's your support for the position that if it's uncontroverted testimony, that it's conclusive? Because my reading of City of Keller and some of the cases that have come out since that, I know City of Keller was a sufficiency case, said there's a difference between uncontroverted evidence and conclusive evidence.
But I would point back off the top of my head, Your Honor, and we could get briefing if it's helpful to the court under the rule 166A. If you fairly read 166A, I think it gets to the present evidence that exceeds the scintilla, and then a burden shifting by way of the response to create a fact issue. So the question is there a fact here for a jury to grapple with? And an example I would use is if we offer an affidavit in our 166A that says traffic light was red, that may not necessarily be conclusive, but there's then a burden shifting to the responding party to rebut that, create a fact issue to bring someone that says the light was green.
Didn't they attempt that here?
They did not.
Isn't there some mention about an individual saying, a surveyor saying I can find it?
Here, the court below correctly struck the two affidavits. If you look at the affidavits on the record, they are the very definition of conclusory. It just says the description is good enough. And so this is an abuse of discretion standard.
Was that what it said? Description is good enough, or was it I can find it?
I'm paraphrasing Chief Justice Quinn. I don't want to misanswer your question. They were very short affidavits, and I just can't remember the distinction of I could find it or the other.
It was I can find it.
Even if it is.
And you're saying that's conclusory. And that's conclusory because it doesn't have supporting data showing how he can find it and what he's basing his Is that it?
That's exactly correct. And again, this is an abuse of discretion standard because it's an evidentiary ruling. So no different than,
Okay, when you asked Coons, can you find it? And Coons said no. Did he state why he could not find it? Did he provide supporting information to bolster his statement, I can't find it?
he did not. And
And if he didn't, what's good for the goose, good for the gander. If the surveyor's statement is conclusory, why isn't Coons? And that constitutes no evidence.
because this wasn't a 602 personal knowledge standard under the rules of evidence, this was a 199 corporate representative designated to speak and bind the company on matters of law, matters of fact.
I understand, but if his statement is nonetheless conclusory, Supreme Court said that's no evidence. Does it matter that he is a corporate representative if what he's stating is conclusory? Is it still no evidence, or because he's a corporate representative? Oh, yeah, well, we can consider it's no longer conclusory.
I don't think that to say you cannot, the company's position is you cannot find this with this description is conclusory. If he wanted to say you can find it, at that point, there needs to be follow-up that says how. But there's an easier way than even the statute of frauds issue to get here.
Well, but let's pick up on this just a minute, though. For it to be conclusive, at least under the summary judgment standard, it couldn't be readily controverted. And it seems like the answer to whether it can be controverted or not would be to take the person and stick them in the middle of section 85 and say, can you find the land or not? I mean, that's something that can be tested. I don't know that that's conclusory or not.
And again, I just bring this back to, if you look at these flat two affidavits, there's not a discussion of qualification, method, data relied on, ultimate opinion, as it would bear on this conclusion. If these are expert survey affidavits, they violate the standards under rules of evidence 702 and 703. If they were intended to be expert, there was no disclosure under 194. And so to just bring this back, again, the trial court's given broad discretion on evidentiary rulings. The court looked at these very short, no statement of qualifications, data relied on, methods, nexus to conclusion, and determined in her discretion they were conclusory and properly struck.
Did the court state what her reasons were for her ruling? What did she say was conclusory? Did she say it failed under 702 or?
Justice, I don't recall off the top. I noted that somebody in the paper said that there was a reference to 166A-C instead of 166A subsection F. And I can't recall off the top of my head if the order was that specific. But again, the court is given broad latitude in these evidentiary rulings, no different than a trial. There's an easier way to get there. The 2010 wind lease would have expired on its own terms in 2017. And you know this from the testimony out of SPS's corporate representative. If you look at first clerk record between 193 and 220, he testifies clearly, unequivocally, and repeatedly for the company that the first lease died as of 2017. The First Amendment was never intended to extend the term. The First Amendment, if you look at it, pertained to other things. And the way you don't need to take my word for it. In the second page of briefing here in SPS's opening brief, they say that the Second Amendment, which was intended to adjust the term, extended the term to the year 2020. That's what they were trying to do. And so they don't realize it, but in their papers, if you just look at their briefing at page 2, they say the second one that was done by the naked surface owner Smalley's was intended and according to them extended the term to 2020. The idea that the first one extended it to 2022 makes no sense whatsoever when you just look at page 2 of their brief where they concede that it was the second one that they were trying to extend this out to 2020.
Well, let's talk about the first one, though. If I understood what you were just saying, I guess that's Exhibit J in your summary judgment evidence. You say, the paragraph A following the recitals at the beginning, landowner in Hell County Wind Farm, initial grantee, previously entered into a wind and easement lease agreement dated August 24th, 2010 for purposes of et cetera. I think what Mr. Smithy is arguing is that this intended to amend the August 24th, 2010 agreement.
Absolutely. It was intended and it was an effective amendment. If you indulge that the 2010 lease satisfied the statute of fraud.
Sure.
Mr. King was the correct person to be signing that in 2015. That's part of just the clear bad faith aspect of the trespass here. Mr. King was the right guy. He owned those rights. But if you look at the entirety of what was amended, that was never intended to amend the development term. It goes on to a number of other different factors and considerations and development aspects. But consistent with what SPS swore to in its corporate representative testimony at First Clerk Record 193 through 220, the 2015 First Amendment was not intended to adjust the term past 2017. You can also see that because in the Second Amendment, they backdated it to 1 day before the expiration of the original term stated in the original lease.
The testimony, was the testimony you were referring to just a minute ago on what the intentions were?
Intention and it was also the legal effect. So as SPS's corporate representative, SPS was required to present a 199 educated and prepared witness to talk about if you're claiming property rights here under a lease, what are they? How do you get there? And what SPS said was that the lease terminated as of 2017, and that it was SPS's corporate position that the Second Amendment executed by the small lease revived it.
Does that constitute parole evidence if we have contracts that would unambiguously say something else?
It is not parole coming back to the 199 procedure. Those depositions are to narrow the issue so that we know what to present to trial courts for determination. As the 199 representative, he says lease was dead. It needed to be reinstated by the Second Amendment. We tried to do that with the small lease. There's a duty under 199 that if that position changes, they have to supplement that testimony in writing because it's a 199 procedure, not a 602 lay witness.
Would you agree with me that if he wasn't a 199 corporate rep, that we might have a parole evidence argument or problem with what you're saying?
Yes.
And so the difference is that it's a corporate rep versus another witness who said, this is not what we intended.
It was SPS's corporate position. That's correct, Your Honor. Additionally, under and I don't want to miss on the substance, ignoring that was SPS's position. With respect to we use a four corners harmonizing approach. We don't look at one word. We don't look at one phrase. We look at the whole thing. There's no way using the Luckel versus White, U.S. Shale versus Laborde, Highsaw versus Dawkins, Navigator Oil, four corners harmonizing approach that you could get to the tortured result that SPS urges here. If you look at the First Amendment executed by Mr. King and harmonize it, it's very clear that what that pertained to was a whole lot of different aspects of the lease. It did not affect the 2017 expiration of the original development term. That was what they tried to do because they knew they needed to do it in the Second Amendment. And in fact, Mr. Kuhn was well aware of it because he was having to go around on hundreds of these leases. They didn't get the project done on time. He didn't just do this once. They had to do this hundreds of times across the project as a whole on the Second Amendments that are throughout the wind project. So
the First Amendment, in your view, did not say anything about extending anything.
Not the development term. The development term remained
What did
fixed.
it, in your view, what did they intend to extend if not the development term?
It's
And was that for 7 years?
With respect to the 7 years, I'm sorry. I want to make sure I'm answering the court's questions on the 7-year piece.
Well, the first question is, under the First Amendment, what did they intend to extend if it was not development?
It goes on, it's multiple pages. There's a subparagraph 3.1, 3.2, 3.3, 3.4, and it talked about aspects of how revenue's paid, how development occurs. It was a very wide-ranging aspect of amendments so I would defer to the actual attachment. What it says is it's being dropped in place of the original 3.1, and it's very encompassing in terms of all sorts of different.
They're attempting to extend other things in your view other than development.
Not even extend, just amend.
Just amend.
Amend, add to.
Did the First Amendment mention something about 7 additional years.
No.
You're saying it says nothing about 7 additional.
It's just through a tortured attempt at using the effective date of the First Amendment to replace the effective date that's stated in the lease, which under a harmonizing approach, which we must employ here, there's no way to get there. And Mr. Kuhn for SPS was correct in his testimony.
So the fact that Exhibit J states the new effective date being in June or whatever, 2015, that doesn't create an ambiguity with what the effective date is?
No, it only speaks to that being the effective date of the amendment. The amendment has an effective date. The amendment is effective 2015. It did not purport to change the effective date of the original lease. And there's actually an example, if you look in, there's an explanation of how development term works. They use the 2010 to 2017 expiration in the hypothetical example that's contained in that section 3.
The development term language in 3.1, I guess. Does that say 7 years from the effective date?
It does. From the effective date, again, if you look at it on its 4 corners, it says take this out, drop it into the original lease. When you pull that out and you drop it into the original lease's effective date, the start of development is 2010. And in fact, as you talk about absurd results, the reading by SPS, which is Corporate Representative rejects correctly, would have that there would be no lease for the first 5 years. There's all sorts of indemnities, insurance, promises that would pertain to that block. And according to them, now there would be no contract that would have covered the first 5 years because we pretend like the contract started for the very first time in 2015. There's just not a common sense way to read it.
In the 3.2, the First Amendment, they talk about extended term. If they were not extending the term, what does extended term refer to?
There's certainly a secondary term. And so if you meet the development obligations by the deadline of 2017, that term goes on to approximately 40 years of development, no different than a primary and secondary term and a habendum clause of an oil and gas lease. If you commence during the primary term, there is an extended term on the backside of that that's perpetuated by operations. I want to, just with the little time I have, emphasize here. The denied request for an injunction was absolute error. There's piles of cases that say where there's an interference with a real property right, such as this here, the court has found there's a bad faith trespass. We've cited in the record where counsel said, until a court makes us stop turning the trespassing turbines, we're going to keep doing it. They're turning today. Our clients have received not a nickel, and the turbines turn today on rights that have been ordered to be trespassing and not owned. Absolutely, this is the precise situation. This is an example, an easy example is the Severing case that we cited out of Fort Worth, in which the court abused its discretion in failing to enter an injunction to stop the trespass. No different than if somebody comes onto your lawn every single morning in a trespassing fashion for commercial profit or otherwise. It avoids a multiplicity of suits. It protects real property rights. Additionally, here, the court absolutely erred in allowing Mr. Grace to testify. This is the classic trial by ambush. He testified, his words, he relied on 10 entire subject matter experts. 10 subject matter experts that to this very day, not a one of them has been disclosed to Ridge here. And so it was their burden with the failure to disclose to show good cause or a lack of unfair surprise, and that must be supported by the record under 193.6.
One quick question on your last argument. How do you believe that harmed you in the outcome that you're complaining about in your cross appeal?
Thank you, Justice Dawson. And I'm at my time. Is it okay with the Chief Justice? So we know it harmed here. This was harmful for this reason. Mr. Grace would have never testified. He would have been excluded under that 193.6 automatic exclusion remedy. It's what the court should have done. The jury's return of $1,049,000 coincides to the nickel with what he offered as his lowest opinion that even he admitted was too low and was wrong. So we know that This wasn't 20 witnesses on the issue and we're fussing over one. He was the only witness they offered. And the jury's award, which is against the great weight and preponderance of the evidence, was to the penny what this man testified to as his lowest number. And so
Does that not require you to send this case back for a new trial?
we agree, and that's what we're asking for by way of relief here. We need we have asked for a remand for a retrial on damages that would be untainted by the erroneous ruling. on the
Liability
expert.
disputed?
I'm sorry, Your Honor.
Was liability disputed?
Liability was not disputed for the reason that there's decorative language in the jury verdict form and in the final judgment that says this is a bad faith trespass as a matter of law.
No, but did Southwestern Public Service dispute liability?
At the summary judgment stage, but their mouths were closed on disputing liability at the trial stage.
Is that what the test is, or do you look at the answer to see if they filed a general denial to see if they disputed liability? And determine whether or not to remand just on damages or for a new trial and everything?
They no doubt dispute, I don't want to be misunderstood. They no doubt disputed liability in their answer. They generally denied. We put it ridge to their proof. The court resolved liability on bad faith trespass as a matter of law, told the jury that it did. And so liability was disputed out of the gate. The court correctly granted judgment.
In your view, it wasn't disputed at trial because that issue had been resolved.
Correct. And
So
we
determine whether or not to remand just for damages or the whole thing under the rule of appellate procedure. You're saying that they would have had to effectively say, judge, again, at trial, judge, you're wrong on summary judgment. We still dispute liability because if we lose here and the issue is just damages, we want to make sure we get everything. We get to go back to new trial and everything. They have to raise something that the trial courts already said, no, you lose on in order to get a remand for new trial in the entirety.
so
That's a very convoluted question. And but I think that's something that we can probably look at on our own.
Yeah, I think what counsel's argument is that once the court ruled on summary judgment, that resolved the liability part.
Resolve liability, but doesn't mean they don't dispute liability anymore. That's my question. But
they are certainly appealing liability.
okay.
They say the judge got it wrong in the summary judgment. The uncontroverted record here is they're bad faith trespassers. The court should be affirmed on that judgment of finding bad faith trespass. We're asking for a remand on the damage piece for the reason I articulate.
Thank you.
Thank you very much for your time.
Well, I told the court there were a lot of issues here, and there are. I don't know really.
Mr. Coon's testimony did not do you a lot of favors. Would you agree?
I agree. It could have been better. But once again, the question that was asked was the wrong question. It wasn't, does SPS know where the property is or can it identify? It was, can you? And you.
Opposing counsel saying that because he's the designated representative of the corporation, when you ask, can you, can the corporation?
Well, I think generally, in a corporate representative deposition, that's the case. But the nature of the question here wasn't directed toward the corporation. It was directed toward Coons individually. And also it was the wrong standard. It was the improper standard from just the description that's provided in Exhibit A. Well, as we know, the standard is not just the words. You can use some parole evidence and you can also reference other instruments referred to. And once again, we have the mystery document of the abstract that's hanging out there and what that abstract says. So it was never produced as part of the summary judgment record. And so, and I agree, Justice Doss, with the comment that you have to conclusively prove as a matter of law on a summary judgment, a traditional summary judgment, which they failed to do because they asked the wrong question.
What's your response, if any, to what Mr. Waymeyer was saying was under Rules of Civil Procedure 199, when you're dealing with a corporate rep, the rules are a little bit different on what types of evidence gets considered and what doesn't get considered under the parole evidence rule.
I would have to agree. They're similar in some areas. I mean, they're different in some areas, but on the other hand, many times these individuals who testify as corporate representatives are also being asked questions individually as well. And for
So,
example,
if Mr. Coon said, look, I'm looking at Exhibit J and I don't think effective date really means June of 2015 for everything, is that binding on your client? Do we look at the
think so.
document itself?
no, I think as a matter of when something, I mean, the construction of a contract is a matter of law. And I would say on the First Amendment, that First Amendment doesn't change the whole contract, just certain sections. And it absolutely deletes the section 3.1, which was the development term. It provides that's deleted and replaced with the new paragraph 3.1 that provides that it'll run from 7 days from the effective date, which is defined in the agreement as 2015. Now, one of the other things that I think needs to be clarified, SPS didn't go out and get these leases, or, what happens is you have somebody bundle these leases together. This is one of the largest wind farms in the state of Texas down there. And there's dozens, if not hundreds, of wind turbines and wind leases down there. And so they put all these together. And so SPS bought the bundle of properties, got title insurance on the property. And there was no clarity. There's no cases that say you can reserve an interest in wind. Now, maybe that's true, but there's no cases that say it. So we had a question of whether we were dealing with the Smalleys or King. We didn't know for sure. There's just no legal authority that would tell us. So that's why you got both the First Amendment and the Second Amendment, which once again were entered into by somebody other than SPS. SPS is just the assignee. So that was part of the uncertainty. Now that gets us to the bad faith issue, bad faith trespass. To show bad faith trespass on summary judgment, they would have to show as a matter of law that first SPS either knew that the 2010 wind lease was void for lack of a legal description, or else that SPS knew that the First or Second Amendment was not adequate to extend the term of that original lease. Would have to show we knew that, and so therefore we had no good faith belief to enter the property.
And I think their argument was, well, that was what you were trying to do back in 2015 and 2017 when you were running around trying to get these other contracts put together.
Well, it wasn't us; it was a predecessor. But yeah, I mean they were trying to figure out how to get this locked down. There's another issue on bad faith trespass, and that is whether the bad faith trespass even applies outside the oil and gas context, and also whether Chapter 41, this is really an interesting issue, since Chapter 41 was amended in 1995, what effect that has on the traditional bad faith trespass in oil and gas cases. Very interesting issue, because it does seem to affect. I'm out of time. Any other questions?
Real quick.
Okay.
Assuming arguendo that we agree with opposing counsel that there was error with regard to damages and there should be reversal, remand for new trial. Think of that. And then the rules of appellate procedure normally state you reverse for a new trial on everything if liability is disputed. When do we determine whether liability is disputed? At the point of the trial, in this case, which was after summary judgment, or from the get-go when you said, or your client said, we generally deny everything, and then you even disputed liability with regard to summary judgment?
Well, it doesn't, the rule doesn't say unless liability has not been resolved. It says if it's disputed. And there's a reason for that, and that's because in a typical tort case, or really any other type case like that, the jury is entitled and really needs to know all the facts of the case in assessing damages. So the idea that you can just go back and try it on damages, it would not yield a fair trial. And so I think it has to be reversed in its entirety and sent back, remanded back to the trial court.
That would make the summary judgment go away.
Well, that's an interesting issue. Assuming the court finds that the summary judgment in total was valid, and assumes that the judgment the order that was entered actually granted the judgment, then, that's an issue the court would have to deal with. If it affirmed that issue, then it would probably decide liability.
The rule speaks to liability, it doesn't speak to a time at which liability was decided.
That's
Summary
right.
versus summary judgment versus liability decided at trial.
Right. And then you
Summary
all,
judgment's a mini trial,
yeah,
is it not?
what's that?
Summary judgment's a mini trial. because
In a
there's no
way, yeah.
Disputed facts.
And so one other thing, it doesn't deal with the unjust enrichment. That was decided at trial in the jury verdict. There was an alternative award for unjust enrichment and money hadn't received. So that was decided at trial. So
Yeah.
thank you very much.
Case is submitted and you are excused to leave and we will be in recess for a short time. Which campus? Safe travels home. Thank you.
All rise.